familiarize you with Form I-485 and information needed to complete a Cuban Adjustment of Status application. It is to familiarize you with potential red flags, to provide an overview of the history, law, and current status of the Cuban Adjustment Act. This webinar does not explain provisions for battered spouses and children. It doesn't explain other components needed to submit a Cuban Adjustment of Status package, and it doesn't explain how to conduct an intake for a Cuban Adjustment of Status application. We're going to start with a quick legal overview. So let's talk a little bit about Cuban immigration policy and the background. Believe it or not, there's been a really long history of U.S. involvement in Cuban governmental affairs. As early as the U.S. War of Independence, United States traded with Cuba. And then in 1898, as part of the Spanish-American War, the treaty that ended the war, Spain ceded Cuba and other islands to the United States. Between 1902 and 1934, there were multiple interventions by the U.S. in Cuban affairs. Then in 1959, Fidel Castro overthrows the government of Fulgencio Batista. Immediately after that, in 1960, the Cuban government nationalizes U.S. businesses in Cuba without compensation. And that takes us to a more escalated relationship with them. Between 1961 and 1962, the U.S. breaks diplomatic relations with Cuba. The Bay of Pigs invasion is launched, which we all know from history was a disaster. And the Cuban Missile Crisis occurred, which was thankfully resolved peacefully. In 1965, the Communist Party began governing officially in Cuba. On August 1st, 1966, 165,000 Cuban refugees without lawful permanent resident status were in the United States. And if you have done your research or listened to my other webinars, the U.S. didn't have a refugee program or a Refugee Act until 1980. So whatever happened before 1980 was a very ad hoc treatment of refugee populations. So because of this, because there was no permanent U.S. Refugee Act in 1966, the U.S. government acted quickly. And on November 2nd, 1966, the Cuban Adjustment Act was signed into law. And that is still in effect today. It is a separate act, not part of the Immigration and Nationality Act. The INA, as it's known, is the body of law that governs U.S. immigration law. The Cuban Adjustment Act is Public Law 89-732. I do provide a link to it in the resources and also in the accompanying essay document that comes with this presentation. So since 1966, there have been some modifications to the Cuban Adjustment Act. The first one was in 1980 through the Refugee Act of 1980, and that's Public Law 96-212. Again, I provide you the link to that. And then again in 2000 and 2005 with the passing of laws to protect victims of domestic violence. There were amendments to the Cuban Adjustment Act, most notably just to make room for battered spouses and children of Cubans. And again, I do provide you the links for those laws as part of your resources. So generally speaking, for someone to be eligible to apply for the Cuban Adjustment Act, there must be a native or citizen of Cuba, be inspected and admitted or paroled after January 1st, 1959,